on the evolution of appellate representation at the U.S. Court of Appeals for Veterans Claims. I just very briefly, before I turn it over to David, who's going to moderate today, I want to thank a few people. First, we want to thank the court for allowing us to come and having it here, particularly Greg Block, Frank Villa, and Lauren, who's been very kind. She is the current secretary and has made sure all the tech is happening today. I also want to thank Jillian and Ashley with the Bar Association for promoting it and helping us organize this. And finally, I just want to mention the executive committee. David Ames is the treasurer, Lauren is the secretary, and Stacy Trumbull of MBLSP couldn't be here today, but she is the vice president. And I do want to talk very briefly. Obviously, the Historical Society has done panels and things of that nature, but we're also looking at working with John Leon back there, who's the new librarian here, to do some things, to get some archives up on the website and maybe have some materials for people who are interested in some of the court's history. And we're going to be working on some of those projects going forward. So I'm going to turn it over to David, who's going to talk and introduce the panel. Thanks.
Good afternoon. So we are here today to discuss basically this. Excuse me for the janky nature of this. The Historical Society is on a budget. Print out a full nice display, but basically what we're here to talk about is what is this line and how did it go down so far? And so what you're looking at here is according to the court's reports, this is the rate of representation for veterans who are pro se before the court from 1994 down to 2022. And the blue line on the top is the percentage of veterans who were pro se at the time the appeal was filed. And the orange line is the number that were percent that were pro se at the time the appeal closed. And so you can see in 1994, 80% of veterans were pro se before the court when the appeal was filed, and approximately 60% were still pro se, unrepresented at the time the case filed. Today, in 2022, we were down to, I believe it was 17% on filing and 8% at the time it closed. Absolutely amazing dramatic reduction. So the question is, how did this happen? And so that is what we're here to discuss. The general format that we will have here is that we're going to go down the line and introduce each person. And they will give you a brief background as to their perspective on this process and kind of where they fit in and what they saw about the pro se representation situation and how it has evolved over the years. And then we will turn into a panel discussion. So,
thank you. I'd like to thank the Historical Society for inviting me to participate in this panel. I think it's very interesting. And one of the things I like a lot about it is his statistics go back to 94, mine go back to 89. So let me tell you what the situation was in 1989, early 1990, when the court first opened its doors. The history was, and it's well understood by most people in this room, that veterans appealed to the Board of Veterans Appeals, and it was de novo review. They would just start over again. You could argue virtually anything that you liked to the board. Veterans at that level were represented primarily by non-attorney representatives from several of the veteran service organizations, although there were some attorneys, fairly few, but there were some attorneys doing that work as well. In my opinion, the genesis of the pro se problem at the court began the day after the court opened its doors, because the entire veterans community believed that this was just going to be a super Board of Veterans Appeals. So appeals to the court poured in. And the service organizations, at least several of them, had no lawyers working for them. And the leadership of those organizations thought, well, this is just going to be like the board. We can go in and argue before the court, just like we argue before the board. They were in for a rude surprise. I am personally familiar with at least two of their supervisory service officers who showed up before the court. To put it very mildly, they did not do well. And so the fledgling National Organization of Veterans Advocates, which really hadn't fully organized and had a number of attorneys, a substantial number, nothing like it has now, began to try to take on these pro ses and help them out. The problem was at that time, there was no effective way for the attorneys to contact the veterans or vice versa. The veterans didn't know anything about NOVA, and NOVA was reticent, as they should be, to be seen as soliciting clients. And so that took a while. But eventually, probably around 94, NOVA began to get much better organized, and the court recognized as well that it had a real problem with all these pro ses. I do not have statistics about what the actual rate of pro se appellants was at that time, but I would be amazed if it was below 80%. And so the service organizations, they deserve some credit. They began hiring a few lawyers and representing their clients. The problem was because the leadership of those organizations did not understand fully the standard of review and the jurisdiction of the court, they initially began saying that they would appeal everything. If you were a veteran and you had a Board of Veterans Appeals decision, if you wanted to appeal to the court, all you had to do was say so, and the service organization would file a notice of appeal. It became very quickly apparent that that was going to be a non-starter. And so the service organizations began screening the Board of Veterans Appeals decisions in cases where they represented the veteran before the board. And if they found merit, appealing. That began what I think is a very long downward, long decline in the number of pro ses at the court.
Mary?
Good afternoon. I'm Mary Flynn. I'm the chief counsel at the Court of Appeals for Veterans Claims Litigation. So my office represents the secretary in all the litigation matters that are brought before the court. I'm here today because I joined the office in 1992. I was a staff attorney, and so I was handling cases before the court, representing, writing briefs, doing oral arguments. And as the statistics show, in those days, we were litigating often with pro se veterans. And so, as you might imagine, it has challenges. And I think others are going to talk about that from the court's perspective, from the fledgling attorney organizations. As a litigating attorney, when your opponent is pro se, but particularly in this context where it's a pro veteran, you're really trying to do the right thing. It makes it really challenging to sort of help without violating your own responsibilities of who is your client. It poses challenges for having contact with the veterans, because one of the changes that happened years later in the rules was now if the veteran is unrepresented, if I need to file a motion for an extension, I don't have to contact them to ask for their position. In those days, you did. So I would have to call them up, introduce myself, and then explain that I'm working on their case and that I need some additional time. Well, there's lots of reasons that they get confused, right? Well, oh, you're my attorney. No, I'm not your attorney. I'm an attorney. And oh, well, so why do you need more time? And well, and so there were just a lot of the lines blurred. It was you want to be helpful, but at the same time, I'm not allowed to give them advice on their claim. So from the attorney's perspective, representing VA, we were very happy as the appellant's bar grew and as more attorneys came into the process, because it helped sort of keep the process cleaner, and it helped, it's better for everybody, really. And I think the court got better briefs, better cases brought before them. In the beginning, it was, you know, you're just struggling. I have an obligation to represent the secretary, but he's the nation's advocate for veterans. So we're trying to do the right thing, which means even if the veteran didn't articulate this error, I have an obligation to raise it. So you really have to do a very searching review of the records, the issues, and then try to make sense of what their informal brief has raised or didn't raise. As a practitioner, I was very happy when we started to get more and more attorneys in the process, and I think it improved the process really for everyone.
Hi, everyone. Thanks for coming out today. My name is Linda Blauhut. I am the Deputy General Counsel of Paralyzed Veterans of America. I'm going to ask you all to forgive me if I get a little teary-eyed, because when I started at PVA in January of 1994, our offices were actually what is now the back of this library space. We were over the garage and it smelled great all the time. But it made filing really, really convenient. As Mary will tell you, the VA attorneys were on the 6th floor of the building. So it was the pre-internet era, the pre-electronic filing era. So all that communication between counsel and opposing counsel was a lot easier when they could come knock on my door, I could go knock on their door to talk about a case. So why do I have street cred, so to speak, to talk to you today? When I joined PVA in 1994, my job was what they called the Part B, or direct representation attorney, because PVA had a commitment with the Veterans Consortium pro bono program to take cases for direct representation to the court. There was not, as Ron explained, there was virtually no bar of regular practitioners before the court. The court recognizes a problem, the VA recognizes a problem, as hard as DAV or PVA would work to screen our own cases. You know, there were way more cases than there were people to take them. And the response to that was a really innovative solution on the part of Congress and the court and 4 veteran service organizations that ultimately became the Veterans Consortium pro bono program. I want to say, I know we have some folks from the program here today. I see Steve and Keith, thanks for being here. And honestly, what the consortium is now is amazing. But what it did then was so focused, and it was when it was new, we were so focused on this direct representation and this education and outreach component. And I told Chief Judge Bartley I was going to shout her out because she was the outreach and education person for a very long time for NVLSP. So the component organizations were DAV, PVA, American Legion, and the LSP. The corporate structure of the consortium was very different at that time. But as someone who worked with their screening component, right, veterans would file their appeal with the court. They would be, the consortium was then allowed to play a role in screening those cases to see if they were appropriate for appeal, right? So we needed attractive to find pro bono counsel. That part that Ron was talking about, where not just anything could come before the court, the consortium was critical in sort of building education in the community amongst pro bono counsel about what could and could not be appealed, and how to issue spot appealable issues. And then we would take 20, 30, however many cases they needed a year when there was not, in the early years it was more because of the just the sheer number of cases, and we're building a bar. So, that was my job for many years at PVA, and I don't know how much more you want. we can have questions or talk later, but that is so that was another aspect of the efforts, and really the community efforts, the veteran community efforts to try to take what was a problem for everyone, and most of a problem for my clients, right? If you were coming to the court pro se, you really are not going to have the best outcomes. So, part of resolving this problem is reaching the best outcomes for the veterans who finally had judicial review available to them. So, that was my start in the business in that role, and in part of the addressing this exact problem that we're here talking about.
Good, Sean.
Hey, I'm Judge Mary Schoelen. I'm a judge on the court in senior status. I joined the bench in December of 2004 and took senior status in December of 2019. So I was not at the court when the initial flood of cases came through the door with no lawyers to help handle them. But I can give you some perspective a little bit on the challenges that I had in dealing with pro se cases, because there were still, at the time that I joined the court, it was around 68% pro se at filing. And it would be less at time of disposition, but the challenges that we had. And then I went back and I recommend everybody look at the court's history book available for X99 or whatever. There's a lot of really good information there about pro se issues and what the court did early on. And I went back and looked at the congressional record of various hearings that Judge Nebaker testified at. And some of the things that were really interesting is like the court created a committee to try and figure out what are we going to do about the pro se problem. And there were various things kicked around. One suggestion Judge Nebaker gave to Senator Mikulski, who was then the chair or ranking of the VA HUD Appropriations Subcommittee, which was the committee that funded the court, was that we should have a federal, like, public defender-like program. And she said, oh, heavens no, because they're underfunded and overworked, and I wouldn't want to wish that on veterans. And when he talked about creating something about the consortium, the consortium bid that won of the 4 veterans organizations wasn't the only one. There was also some private attorneys who tried to become the people who represented veterans at the court and were funded by Congress. At one point, Judge Nebaker tried to get the court really out of the consortium business because there was a across the board budget cut in the Omnibus Budget Reconciliation Act of 1996. For fiscal year 96, the court received less money than it had requested for its operational budget. And the consortium was to be funded out of the court's operational budget. And Judge Nebaker went to Congress and said, you gotta give us some more separation here, because this is putting the court in a position that creates an appearance of impropriety, that we're somehow favoring one side over the other and taking money out of our own hide to fund them. So there's been a lot of iterations over the years to get the court and the bar and the pro bono community and the pro se community to where we are now. And I can talk some more about challenges and other things as we go.
Andy. Thank you. I'm Andy Reynolds. I'm an attorney for the central legal staff of the court. This is my second tour here. I first started in 1992 and to 1999. And then somewhere in there, I represented veterans at MDLSP for a few years. And then I made my way back to CLS, where I've been ever since. So my angle today will be a little bit about how the change in the pro se numbers, how the decrease in the pro se appeals has changed the way the court is operated, and namely its central legal staff and how we operate. I actually used to do conferences in the 1990s. I think I'm correct, with Linda, Mary, and Ron. So that was before we had the Rule 33 requirement of summary of the issues. So CLS would look at a board decision, decide if you wanted to do a conference. And, if you did, you shoot that out there, you do a conference, and sight unseen, you just get on the phone and see what happens. So it was interesting because there was more conflict back then, because everybody wasn't as prepared as to what was going to happen. Needless to say, though, the high pro se rate was problematic, is a number of people mentioned, one thing that Mary said was the blurred lines. You know, back then we had the record on appeal. And with a pro se veteran, a record on appeal could be almost the whole claims file, you know, it could be this, sometimes it went up to the ceiling. So those constant conundrum, whether it be back then, because of high pro se, we screened a lot of cases for the court, you know, less competent, that hadn't taken off yet. And they wanted to have someone help look at all these records and make some sense of it. But it created a conundrum. How much time do you spend on this case, right? How much do you help or not? And, you know, I'm sure even the judges at the end of the day, like, you know, making their decision, that same thing. Mary said the same thing, you know, as a VA attorney, line attorney, how much do you help? So it did create more work, but, you know, it was a lot more hours, it was a bigger backlog. But it was rewarding in its own way. But it was also a crazy time period because you had things like we dealt with more World War II Philippine veterans, for example, and that created its own issues because you're dealing with someone halfway around the world with mailings. Lots of Rule 10 conflicts, a lot of pro se, so there are a lot more Rule 10 disputes. And we did back then, a lot of our paralegals handled the Rule 10 disputes, so that was a lot of hours spent on that. And then you just had things like jurisdictional issues, like a date stamp, you know, on the filing, did they meet the mailbox rule or not? So it all created a lot more work, but part of what, you know, you'll see as we go through this from CLS's perspective is how our duties have changed and evolved. Most notably, once Rule 33 was implemented and you had some of the issues requirement, and then I think it helped take off and more attorneys got involved in the process. That's it.
Thank you. One of the first things I wanted to talk about, most of you have actually covered in some sense, but just in case there's any additional comments, before we get into what was done to bring down the pro se rate, it's kind of a question of, well, why should we bring down the pro se rate? It probably seems obvious that most people who are attorneys, but you know, for posterity and to the extent, you know, for those of us who are on the private bar side and haven't had to be on, you know, working on a case that is pro se inherently, you know, what is it about a pro se case, to the extent that you haven't already discussed it? What is it about a pro se case that makes it more difficult to handle, such that it is better to have representation?
Well, if I can jump in, there's a whole bunch of problems that comes with dealing with a pro se rate, a pro se case. One example is the veterans don't know the procedures that we have at the court. And so there's a lot of, this doesn't meet the filing requirements, this doesn't comply with the rules, so things get sent back over and over and over again. And it creates a lot of delays in their own cases. I would have some veterans that would just ask for an extension, and then another extension, and then another extension. And I was very torn, because I said, it's their case, so if they are okay with the delay, but at the same time, kind of got to keep things moving, got to keep the train going. And so that was always a tension of, you know, do you let the parties drive the time, or do you do it? What are they even saying? A lot of times things are handwritten, and the handwriting could be very illegible. And then even if you could read it or it was typed, the arguments were frequently unclear. There'd be a lot of legalese that sounded highfalutin and impressive, but it was you couldn't figure out what it was that they wanted to say. And a lot of times they would argue about something that wasn't in dispute. Like they would present statements about service connection, like what were the events that they experienced in service? Like, I think they felt very strong that they needed to get their experience in service out, which I respect, but we're now talking about rating. And so that doesn't help me decide whether the board decided your rating case wrong. Appellants sometimes didn't understand or still don't the remedy that they're receiving, that a remand is a good thing. And they would appeal that to the federal circuit, or they would file for reconsideration or something else. Particularly in petitions for writ, we would get, we still do, appellants who file things that have already been decided by the court again and again and again. And the problem with that is it's taking up time that you don't have to decide other people's cases, because you're having to decipher if there's something new in what they're arguing, what they're not. I had one veteran who's kept filing petitions, they kept coming to, they were assigned to me. One of my clerks literally had a file drawer full of his filings. And we gave them careful consideration every time, because usually there was some little nugget in there that would be valid and relevant, but you had to really parse to get through all what was new. And well, we already talked about these 12 things, Mr. Veteran. We're not going to do that one again, but we're going to talk about this one thing that you haven't talked about. Sometimes the court actually, the judge would impose some boundaries on these veterans, because in a way it's almost an abuse of the process, taking away time from other veterans cases. So we might require them to pay filing fees that ordinarily would be waived, or we might require them to ask for leave of court before they could file something new, which is sort of ironic, because then you got to read what they're saying and see if there's something new to decide if they can file something new. But you know, it's at least a little extra step for them. I've had pro se veterans try to contact my family members or contact me or my clerks directly. And you know, generally it's well-meaning, but it's still a little disconcerting, and it's inappropriate to speak to a party ex parte. So that's a challenge, because they don't understand that they can't do that. And then when we get to deciding the cases, it can be challenging. We have these complex novel questions, and we want as much input as we can get. And if we're only getting it from one side, you know, we do as much as we can on our end to research it. But I've also requested amici in cases. The court will resend a case to the consortium if it is a case that is going to be selected for a panel for oral argument, to see if counsel can be secured in that contact. But another disadvantage for the veteran is if there is no attorney, the court is not going to schedule oral argument anymore. So they may be disadvantaged that way, to the extent people perceive an oral argument as advantageous. And because the court early on tried doing arguments with pro se veterans, and my understanding is they were not very productive. So that's sort of a little window from the chambers out to the pro se world.
I have been dismayed from time to time by the number of attorneys that I've encountered who don't have a clear understanding of jurisdiction and standard of review. But if you think attorneys don't understand it, wait till you talk to some of the pro se veterans. And one of the problems that we confronted, by the way, my last 11 years were in private practice with Finnegan Henderson here in Washington, and we would get pro ses who would contact us and ask us to take their case. And it was extremely difficult to explain to them that they could not appeal a decision the board never made. They're trying to raise an entirely new issue. And even though, and we tried to be completely clear to them that we were not their attorney at that point. We had not agreed to take the case, but nonetheless, we felt an obligation both to that veteran and as much to general counsel and to the court, that this person, first of all, understood why they could not raise that issue at this stage. In some cases, they could go back and raise that issue in a new claim to the VA, but you couldn't go to the court. And if they tried to go to the court, not only would they be wasting their time, they'd be wasting the court's time and Mary's time and all of her attorney's time. And that's to be avoided. And then, of course, standard of review. laymen want to argue the facts. And it's very difficult, or can be very difficult, to explain to a layman that what you're really raising is a factual dispute over which the court does not have jurisdiction. And one final thing, I believe Judge Schoelen mentioned veterans from overseas. And I've elected to represent veterans from the Philippines. Now, if you think it's difficult to deal with somebody in the United States who speaks Spanish, I do not. At least I can get someone on the phone to translate for me and help to communicate with that person. But when you're doing it with an exchange of mail, email's doesn't work in the Philippines, or didn't at that time for the most part. It can be very frustrating, not for me, but for the client, because they simply don't understand.
One more thing I wanted to add is frequently veterans will want us to consider new evidence that wasn't before the board that has come along in the intervening time. And so that's another issue. And, you know, and I can understand it'd be frustrating, like, oh, you've been waiting another year or whatever to get here, stuff has happened, but unfortunately we can't do that.
Any other commentary on the difficulty of handling pro se cases?
Well, I would just kind of echo what Judge Schoelen and Ron have said, but I think sort of in a nutshell, from the VA's perspective, was sort of the issue spotting and figuring out what, like Judge Schoelen said, what are they saying? Which of these issues is it the whole decision they think is wrong? Are there discrete issues? What part of it? So you really didn't get much, mostly you didn't get much help from the pleadings. So it was really, you are going through yourself, trying to figure out which of the issues have validity and which ones don't. Andy mentioned the record dispute. So one of the later rule changes that's been really good is in that whole record process. But in the early days, the first stage was VA would designate the record. So it would be our staff at saying, this is what the board looked at in paper files. So there were, you know, stickies and going through it, and then it would get Xeroxed and it would get all put it together and it would get shipped off to either the pro se or if there was an attorney involved. The next step was they get a chance to counter designate. So as Judge Schoelen mentioned, this is where they go, this is missing. You know, I just saw my doctor last week. Here's 30 pages. And it's like, yeah, those can't come in. And these we already have. And you would get this stream of papers back in, often duplicates. A lot of time they had their own annotations on them now that they wanted included. And it's like, well, no, those records are already here. And so we would have a conference with the court's legal staff, and we would try to explain why these things can't come in or why they already are in. And it was not a particularly satisfying conversation, really, for anybody, because they would go away angry because they didn't think we were considering everything. You know, it was frustrating to us to be trying to explain over and over again, well, but this is an appellate court. They can only look at what the judge, you know, what the board person looked at. And then at the end, when you resolve it all, that would be so that in and of itself could take months just to get the record. So now just having basically the whole C file now is digitized. I mean, it's just so much better. So that was a particularly challenging aspect with pro se's, just even figuring out what the record is going to be that the court will look at. And then the layers on it, and then what are the issues? Because as others have mentioned, they would frequently bring in new issues, or they would raise claims that were being covered somewhere else in the VA system. And so you'd have to figure out, well, where's this claim? I don't know, you know, we'd have to kind of do some research to figure out, was that a claim that should have been here, or is it already being developed? So it just made it very kind of murky, and again, sort of the process was very just kind of cumbersome.
Andy? do you have something?
Yeah, I just want to confirm, like the organization of the record on appeal. I mean, it was crazy for everybody. And plus you had these paper copies. And you are not always, I'm saying that, you know, loosely, but invariably somebody would lose one of the volumes or it would get stuck, you know, and somebody, you know, I'll take like my office if I had screened it or some, or maybe it got lost in transition and there were these files all over the court. And it was a handful just to keep up with the files, the paper files.
All right, then let's turn, I mean, obviously, the first solution that was derived and the biggest solution was the creation of the Veterans Consortium. So can we talk a little bit about how that was arrived at as a solution? I think Judge Schoelen, you talked about some of the legislation originally, but before we get into the consortium itself and the impact it started to have, how was that determined to be the solution? Any commentary you have on?
I think Judge Steinberg was very involved in this process at the beginning of deciding that this was the way it should be. I couldn't find like what was the genesis that created this, and I apologize. I was going to try to talk to Judge Nebeker last week at the portrait ceremony, and it didn't happen. Basically, the court went to Congress, and there was a delay in fully or in appointing all of the rest of the judges when the court was created. The first 3 were appointed fairly promptly, but then the remaining 4 took some time. So there was some money left over in the court's budget because they didn't have to pay the judge, their clerks, the secretary, buy furniture, things like that. So the court, Judge Nebeker went to Congress and said, hey, we'd like to put this money aside and put it, pass through the Legal Services Corporation, create a grant for the court. And Linda's got some handouts here, so she may be able
I
to.
was just gonna say, I just haven't got anything that spurs your memory. I will say for after the fact, for those of you who are interested, the consortium's website still has some of its annual reports up, and the one from the 20th anniversary year does do a timeline of sort of what happened when. So if you want to go back and
Flush it out
and look at the you know, look at it in print as opposed to just hearing, or if your interest is piqued after hearing Judge Schoelen talk, then that is available online.
And so the appropriations committee basically put some language in their appropriations bill and created this process that they were supposed to create a grant and people were supposed to apply for it, and then it was a pilot program. And a couple of years later, Judge Nebeker went in to testify about how's it going and should we keep doing it? And he said, yes, we should definitely keep doing it. It was a pilot basically to see if it was working, but you should keep doing it. And I think Congress thought it was a good thing that was happening, and there was a lot of hearings where the problems with pro se's was acknowledged and discussed. And one of them, very amusingly, Senator Alan Simpson, who, for those of you too young to know, he was like a kind of a cranky, like tell it like it is kind of guy. And he was very frustrated that people were taking the cases through the consortium, but then they were still getting teacher fees for that. He's like, in my day, pro bono work was pro bono, and I took a lot of pro bono cases that I didn't want to take, but I didn't get paid for. So he's like, we're gonna have to look into that, but I don't think that ever happened. But so the process, you know, and then ultimately the process to create what was the consortium was something that you guys can illuminate on, but the court really tried to help. I think Judge Nebeker had a relationship with David Isbell, who was very influential in the early days of getting folks involved. Judge Nebeker did a little bit of lobbying amongst the law firms in town to try and get people lined up to, would you be willing to take pro bono cases if the court created something? And people were sort of like, yeah, sure, I'll do it, but I only want good cases. Because if I'm gonna have my young associates doing these to get training, I don't want them to have bad cases. So as Judge Nebeker put it, like, they wanted us to separate the wheat from the chaff, but he didn't feel that the court had the way to determine what was wheat and what was chaff. Because he felt like that wouldn't be able to happen until after there was briefing, and there couldn't be briefing if there wasn't an attorney. And so that, I think, was part of the idea for the screening component, and was to ensure a way the pro bono attorneys were going to take the cases, that they were going to get something of substance, and that they would be willing to do it then. So.
Just to add a little bit to that. Another problem that was encountered with large firms, particularly taking cases at this court on a pro bono basis, was they were all very nervous about their malpractice insurance. So they would do great work. I could name 2 or 3 big firms, I won't, who would take a case and then put a team of 4 or 5 attorneys on it, and they would work it to death. In the meantime, hundreds of pro se's are going unrepresented. So I personally, I don't think the Veterans Consortium can be given enough credit for their work. First of all, screening cases, and then contacting these pro se veterans, most of whom never had a lawyer before. And now all of a sudden they've got a lawyer they can talk to. And in many instances, that lawyer provided a tremendous service to the veteran and to the court by carefully explaining to the veteran that it really wasn't a case within the court's jurisdiction or had any reasonable chance of success. Now, their job was not to talk them out of it, but the job was to give them a clear-eyed view of what the probabilities of success were. And I think that's one of the tremendous milestones of the consortium, and really indicates how valuable their work was, is, and will be.
Can someone comment a bit on, at least in these early days, between like 1990 and 2000, what was it exactly that the consortium was doing? How did it operate to bring in attorneys at that point?
Well, I can speak operationally, just to pick up on a couple of things that Judge Schoelen and Ron just said. The EJA fees, the court, Congress expanded the EJA statute to include the court in 1992. So I really don't, it's very difficult to separate the availability of fees from the development of the bar. Had EJA not been available for practice before this court, we probably wouldn't have had the growth in the bar that we had. The availability of that, I think, became an incentive for a lot of people, because what happened was, one of the things that the consortium did was train anyone who wanted to take a case. There was no bar, and you were creating there was a very tiny bar, I should say. So, but in terms of people who had other kinds of practice experience and wanted pro bono work, it was a place to go to get the training and then be assigned a case. And you could be with a large firm, like Ron just mentioned. You could also be a solo somewhere who maybe you were a veteran yourself, or maybe your dad was, and for whatever reason you felt strongly about if you were going to do pro bono work, you wanted it to help veterans. So the availability of EJA, sometimes you would see things like from the large firms, they'd apply for the fees and then donate them back to the consortium. For a small firm practitioner, that availability of EJA can make a real difference in their ability to maybe continue to do more pro bono work. So,
Well,
everybody's like,
I actually went through the training in the mid-90s, back when I was working for Vietnam Veterans America, and I remember talking with other folks who were attending it, and several of them were solo practitioners or whatever that were thinking about getting into veterans law, and it was their foray by getting this training and mentoring that they thought that this would be a good way that they could then start doing it. And so I totally agree that that was a big factor. With the EJA, the court actually had decided an en banc case that decided the court didn't have jurisdiction to award EJA fees. And within months, Congress had passed a statute allowing the court to pay EJA fees. And so that was a big thing.
We'll fix that up. But but in terms of the actual sort of functioning of the consortium, the screening process, each organization in the 4 organizations that comprise the consortium donated employees. So they remained an employee, like PBA had screeners. They remained PBA employees, but they went to work every day at the consortium. And I also want to emphasize that, remember, we didn't have attorneys. These were non-attorney practitioners. So really the early years of veterans law are built on the expertise of people who spent careers as service officers and you became expert in how VA worked within the agency. Because who else spoke that language? So the court was created, but the only people who really spoke that language were the people who were living it every day anyway, because they had been doing representation for the regional offices of the board. So most of the screeners who came through, at least in the first few years, were not lawyers at all. They were very experienced service organization representatives. But they would do the issue spotting and they would prepare a memo. And one of the other interesting things, I probably still keep the statistic, the element Ron was talking about with the value of explaining to somebody why your case maybe shouldn't proceed to court. There were the places that there was an issue, a judicial, I'm not sure if that still came out right. An issue they could bring before the court. With that. That there were, these were the cases that could be placed with pro bono counsel. There was clearly something that would be there for the court's consideration. In a case where maybe that wasn't the situation, that veteran still got contact from the consortium explaining why. So that is still a form of service to that group of veterans, even if it turns out that their case cannot be, it's just not appropriate for appealing at that time. So in some years, it was sort of an even number. You might place 250, 300 cases for the court. You might also offer 250, 300 veterans the advice that this is just not the case to bring, or it's not your time yet. So, that you had these things sort of going in tandem. It wasn't just that there were cases being placed, they were also providing this other service at the same time. There was a mentoring component. So once a case was placed, there was a mentoring component. That was something our office did. I'm sure folks at DAV did, and folks at LSP did, that, someone in, law firm XYZ gets a case, they don't know anything about the practice before the court. And let's face it, VA is a very lingo heavy practice, right? So to have a phone number, a direct line of somebody, or later an email that you could say, hey, I've got this case and I saw this thing in the record, I don't know what it means, or when the court's rules say I can do this but not that, how do I file that motion? I think that also offered people a lot of sort of made them very comfortable taking that kind of a case. If they're going to pick a pro bono area, it made it a comfortable pro bono area to turn towards. So it became attractive for that reason as well.
You said something that it touches on something that I have actually some curiosity about, which is we have multiple people here who are attorneys who work for service organizations practicing before the court. And yet, the service organizations themselves were major backers of the consortium. But why did the service organizations see the consortium as necessarily a solution? Why didn't service organizations themselves hire attorneys and go represent directly before the court?
Well, I mean, and my own organization, now every organization is different. My own organization is an example, right? We're a nonprofit. We're based only on our donors' generosity is what controls how many people we employ at PBA, and serving our members controls where we put those people out in the field. And so now on one hand, I will say that in terms of the traditional veteran service organizations, congressionally chartered organizations, PBA is the one that we still do top to bottom, bottom to top. We can walk in at the regional office and we can represent you either through a service officer or through an on-staff attorney through the entire process of litigation. But most organizations didn't traditionally staff that way. And honestly, I think the problem was better solved by a community response, right? If we had 5 or 6 different organizations doing it this way, that way, the other way, we might have gotten there eventually. An aggregate response, though, I think is a better response, especially because of that adding the training component. right? That you're part of, somebody takes the class, think about representation, gets assigned a case that they know has some sort of merit to it, gets the opportunity for a mentor. That systemic response, I think, was far superior to anything an individual organization. You just wouldn't have had the reach.
Yeah, it leverages the resources better. And in a way, I think it was also a value to the court to have outside perspectives come in, because some of these issues are not necessarily VA specific things like equitable tolling or things like that. So I think it's helpful to have perspectives from people whose practice is outside of our little insular universe and look outward sometimes.
So I'd like to get back this chart a little bit, because I think this has some relevancy to how PV's calculated, which is there's this big gap between the filing, the pro se rate of filing, the pro se rate at closing. And if I understand correctly, this gap here is to a large extent from the Veterans Consortium helping to secure representation once the cases are filed. But that only happens once the case is filed pro se in the first place. So, what difficulties were there in dealing with the initial filing rate problem? And how did that eventually start to go down along with the rest of it?
Well, some of the difficulties we've discussed is, veterans didn't know what to file or how to file or where to file. The history book notes that people were submitting things on like paper bags, notice of appeals. So the court took a bunch of steps. For example, they set up in like 92 or so, a 1-800 number for veterans to call in. Bob Camo really placed an emphasis on hiring veterans who could answer those phone calls and work with those folks from the public office and the clerk's office and give them information on how to move through the process. So I think that was a big step. One thing I wanted to back up when you talk about the gap was sort of the consortium. Part of it's the consortium, but part of it is also private attorneys would reach out to veterans who had filed pro se. They would come in here to the court and they would screen the file, I mean, the
Case file.
the case file, that's what I'm looking for. And decide that there was something, a justiciable issue. Showing off now. And they would reach out to veterans and, in states that allowed advertising and reach out to them and take on cases that way. So I think it was, pro bono consortium on the one hand and the private bar growing on the other, that was that in between gap. So those are some of the things the court did, and then over the years, there was more things like, when we moved into e-filing, the court's e-filing rules had sections that contemplated if you were pro se. We allowed veterans to communicate with the court by email and to file things. Historically, the people would file things by fax. And Greg was telling me they modified the notice of appeal forms, the court created forms, that was a thing. Modified the notice of appeal form to put an email slot on there so that veterans could be communicated by VA or by the court by email. And then subsequent to that, the court has worked with the consortium to set up a helpline to reach out to veterans who were calling the public office. And, again, talking about blurring the lines, our folks aren't supposed to tell them how to do, or what's the best thing to do, just how the process works. And so this way they could talk to an attorney. And then sometimes that results in them saying, oh, lawyers aren't so bad. Maybe I'll go ahead and take a pro bono counsel from the consortium. So that kind of had an indirect.
Andy?
And just kind of support what Judge Schoelen was saying, the court actually had a reading room, because we had the physical files here and the case.
That weren't in your office.
Yeah, that's right. So you had the claims file, which was like gold, because you didn't want to, they kept up with that, but like Judge Schoelen said, the attorneys would come in, literally check out these files, and you put something like this, although I think it was a different color, maybe it was yellow if it was a claims file, right? They had different colors for them, and they would take these files into the reading room and read them. So just sit on the pro se cases.
Can I ask, Was there any authorization required by the veteran to allow other people to see those? How did that work?
It's public, yeah. I mean, as far as I know, I'm saying this to. confirm.
I hate to say, but think about the website now, right?
That's how they do it. It's a
Access
public
to the
file.
website.
All right. We've touched on a bunch of things that has been done other than, sourcing itself, but let's talk about this growing influx of new attorneys. Mary, I'm sure that, things certainly got easier in some ways by having fewer pro se cases, but there must have been other complexities from having a surge of new attorneys coming in to represent people. So were there any downsides to this initial rush of new attorneys coming in?
It's a downside. I mean, there's a learning curve for everybody, right? When it's the same as when we hire new people, we hope that there's going to be some generosity on the other side if we're not as, quick to pick up an issue. And I think our staff helped train and was very patient in kind of helping a new attorney, somebody new to the area. But the training that's been mentioned was also quite good, and having a mentor assigned was a real lifeline. And so we would often get a case and we would, if we're talking horse trading on a JMR or something like that, there would be I'll need to check with my mentor. And then it was, okay, phone a friend, and they would chat and they would come back and say, okay, yeah, this sounds good. And that was just part of the process. We just sort of knew there was going to be a little bit of give and take where they would have to check to make sure we weren't trying to lead them down, the primrose path. And they would say, oh, yeah, no, my mentor says this is really good. So yeah, we can agree to that. So that was just, it just kind of added a new element to the process. And I think we sort of quickly knew when there was somebody new to the process. And they were generally very upfront about it. Like, hey, this is my first VA case. I think I should be doing this, and this is where we are. And, we sort of work through it.
Yeah, Andy, how did things shift for you?
Yeah, I think, well, when it came to conferencing, back in the day, when you had the pro bono attorneys, it was a little looser process, and you kind of needed, and the DA was more generous. You needed them to be more generous in discussing a lot of just procedures, but also even some of the issues. So, again, that blurred lines, but they really probably needed to bend over a little more, I would say, earlier, years ago when pro bono started. But I mean, the pro bono program did a great job. The training, I think is what helped get the word out there. So,
When it was interesting, again, reading in the congressional records, the transcripts, Judge Nebaker thought that the only pro bono attorneys would be in the DC area because of sort of the paper nature and all this. And I don't think at the time he contemplated at all that it could be countrywide the way it is now. So it's been a tremendous change. But one thing I was gonna mention about the influx of attorneys, one of the great positives was I don't think we could have done the Rule 33 process if there hadn't been such a higher volume of represented veterans, because it wouldn't have had the impact that it did. And frankly, the conferences are what keeps the court alive, because there's no way we could be above water, keep our heads above water with 9,000 appeals a year if a majority of them were not disposed of through the conference process. And that's only possible because there's attorneys. And so then that leads to the Rule 33 pilot program by trying to get attorneys involved in at least representing veterans in the conference process. And so that's been another new iteration that's sort of playing out, and the consortiums played a role in that as well, and Greg's shop and the VA and the JAC and have been tremendous in figuring that out and then tweaking it and trying to figure out ways to make it better and easier for the volunteers to do the job that they're doing. And reaching out to more veterans. And so, you know, the iteration doesn't stop. The court, even though our pro se rate is very low now, the court's still working with our community to try and find the best way to help veterans.
One thing that doesn't directly follow on this, but you know, it's interesting on a pro se rate is Judge Schoelen talked about this briefly, this issue, that petitions are actually something of an outlier. You know, that the chart I showed is just about appeals, and the pro se rate on appeals is very low, but the pro se rate on petitions remains very high. I think in 2022, the petition rate is, and I wrote it down here, 60% at filing and still 52% pro se at closing for petitions. What is it about petitions that makes it significantly harder and it gets them treated differently and it makes it harder to get a representation on
I expect, yeah.
But also just the standards are different, right? It's pretty darn difficult to get, and it's depending on what they're petitioning for, it could be a very short-term representation. So you're, you know, in terms of you're looking for, if you're somebody who wants to take a pro bono case, and maybe that's not the ideal kind of case that you're looking for. You know,
When the time to get matched up even with
Right.
somebody,
right,
I think,
deadlines are moving, the standards are high.
My guess is also that I don't know, I haven't seen numbers, but I'll stick my neck out and say probably the number of petitions that are filed now, I don't know what the rate of claims are, but proportionally are probably not as high as they were years ago, where we got lots of.
I don't get those anymore, so I don't know what the current inflow is. One of the beauties of being a senior judge. But I can talk about like when we would get represented cases, represented writs for petition writs. Typically they were, VA isn't letting me have the claims file, or there's supposed to be an exam and it's been 3 years or whatever back on remand. So they were very specific and targeted and somewhat easy to resolve, and VA frequently something would happen and it would get resolved very quickly. With the pro se cases, the writs were much more kind of sometimes a substitute for an appeal or open-ended things that we had no jurisdiction over very frequently. They wanted to sue judges in other courts. You know, all sorts of any problem that relates, and I'm a veteran, we would see something about that. They're very challenging to deal with. And it would be nice if they were represented. Great, start working on that.
I am curious for anyone who's worked on this, because that chart shows a relatively long 30-year decline in the pro se rate. At what point did it feel like it is today, or it feel like a period of time where the pro se rate was, I don't want to say largely like solved, but when it was stable and no longer a primary issue? How long did it take to get to that situation? And
I feel like once the rule 30, well, I mean, it's like we commented. Yeah, right. Well, because you had, less pro se's, right, that allowed us to start CLS to focus more on the conferencing process, and hence rule 33. I feel like people had to get used to that a little bit. Maybe not, even the process is like a dance, right? And starting out, you have the summary of the issues, and, it's still, you actually now have something on paper. And so it's still that feel of litigation a little bit, because the VA's going back to look at this and which one do we, agree to and not, where should we butt heads and not. And so it's still a little bit of that, but then I think after a number of years when the process had panned itself out and everybody got used to it, I felt like it really found its groove and took off. And then you saw that as evidenced by more JMRs and all that.
What year did the Rule 33 process start? Approximately?
2008, it came out of a result of the bench and bar that they had in 2007.
Also, that sort of coincides with, I mean, you have been doing this, all started in the pre 9/11 era. And after 9/11, of course, interest in veterans and military issues just skyrocketed. So we think about the amount of interest that people began to have in what is happening in veterans cases. You know, that would make, it sort of coincides, right? That would be about a lead up time for people to get interested, get educated about the process, start taking cases, increase the number of people who want to be part of this bar.
And I felt like it added a certain little bit more sophistication to the process, right? All of a sudden there was more structure at the court. This was more something now that you could get better acquainted and teach a class in law school, and then get, you know, more students involved in writing some of the issues. So the whole thing just really, I think.
In the courts, the bar association, you know, that played a role as well. And as the bar, you know, grows, you know, kind of word of mouth, and people see that you can make a good living with it, and it's a fulfilling career. You know, it sort of feeds on itself.
I was trying to look at the chart that you provided us and sort of some of the dates, and I think one point may have led to some of the decline also is in 2006, effective in 2007, Congress changed the point at which people could hire and pay an attorney to represent them. And it moved back from being when there was a final board decision to when there was a notice of disagreement already filed. And so that, I think, got more attorneys involved within the agency also, but it gave them more opportunity to get involved in the case before it got to the court. And so I kind of think like within a couple of years after that, like the numbers of attorney involvement got greater as well. But for me, I don't know that I could say when I noticed a difference, but with more and more cases being resolved in conference, sort of, it almost disproportionately looked like we had pro se cases because those had to come to chambers. And so it wasn't like they were ever the majority, but it wasn't like there weren't any. And now I only get 1/4 of the caseload of a active judge. But I think this year I've only maybe had 2 pro se cases so far. So I feel the difference.
You know, I think there was a long period of time in which it was simply a phase of building the bar, you know. Veterans Consortium program was working and helping to train people, and people were coming into the bar on their own. But we did recently have a new program to try and deal with some of the stragglers on that chart there, some of the pro se people, which is the current Rule 33 pilot program. So, Andy, you want to talk to us about that and sure, you know, what that process is and how it's going?
Yeah, so the idea is that if somebody is still pro se, by the time the court issues, you know, the notice to file their brief, or in this case, maybe an informal brief, the TVC, you know, will get notice of it, and they'll try to see if they can get an attorney to represent the veteran for the limited purposes of the Rule 33 conference. So they'll reach out to the veteran, and if so, then they'll represent them for that limited purpose. And then, you know, if they want to stay on the case, you know, they can, the attorney and the veteran wants to, they can continue on. It's been pretty successful. The numbers that we all have show there were 239 Rule 33 conferences held. 123 of those resulted in a JMR, so that's over half. But also the benefit is that even in case where there was no JMR, but the attorney stayed on, continued, there were 53 So there's, of course, the added benefit of that. I went and looked at about 35 JMRs in these cases. So just for informational purposes, then what I saw, and of course, there's always, anything can happen in a case, but some of the commonalities that maybe I saw is maybe the cases did not tend to have as many claims involved, multiple claims, like 3 or 4 or 5. Like we see maybe more in cases that are represented, where attorneys have taken them on earlier for whatever reason. Fewer claims. The bases for the remand was maybe also a little more singular. Maybe it was, they went through the record and, there was this one form that they see that was not considered, whether it was maybe something involving an earlier effective date, that somebody missed something back here. So that's just kind of what I saw, but it's been successful,
All right, we've covered a lot of topics. Is there anything that we haven't touched on that you would like to comment on?
I just mentioned that I think that there's also a role for the law school clinics to play in this. For example, they can share with the consortium particularly in cases that are like non-fee generating or non-high fee generating cases that might not be attractive to private bar. And some of them have different emphasis, so, like Yale clinic push the class action stuff. So the impact that they can have has been significant, I think, as well.
Could we potentially give the law schools petitions?
Like in the way you think.
Any other comments?
I did a very few minutes of research, just thinking about like, okay, what's a good number? What should we have a target number for, and can you ever really prevent pro se? I mean, there are some folks who really don't want your help, right? They've always done it themselves. They want to keep doing it themselves, or they don't trust somebody else to handle their case or whatever the thing may be. And so there is an organization called the Judiciary Data Analysis Office, and there are a lot of federal areas that have really high pro se filing rates. I learned in my few minutes of research, and if you think about it, it makes sense. Right? Bankruptcy, immigration, forgetting prison, just take prison appeals out of it. So, but in U.S. district courts, there are just a lot of Social Security, of course, and a really high number of civil rights cases start off as a pro se filing. So I thought, well, once I realized that, I'm talking numbers like 60, 70, 80% pro se at filing in the U.S. district courts. So we're doing pretty well. I think the system that's developed in the management, I think it's something to be applauded that got good management here.
At the time of the creation of the consortium, the comparison that they were making was that the federal courts had about a 1/3% pro se rate, and our court was hoping to get down to that.
1/3%?
No, a third of the cases.
Oh,
I'm
okay.
sorry. A third of the cases were pro se. So we've far exceeded the goal.
All right. Do we have any questions from online or in the audience?
Don't have any online yet.
I had one, and I think maybe this has been answered already when you mentioned the 1-800 number, but I was curious about what other efforts there had been to meet some of the pro se veterans where they were. You talked about maybe some procedures too trickier. What was the court involved in trying to simplify procedures or explaining maybe what a remand means, in the decision itself, explain to them in practical terms what that means and things like that.
Well, like I said, the court created forms, sample forms. I think that was helpful for folks. I know I always tried to write in more simple English, like not a lot of Latin, things like that, so the veterans could try to understand. I would frequently put in and still do a large procedural history, so the veteran can feel like their case was seen and reviewed, and they had their day in court, even if I don't necessarily find in their favor. And I think the court, at one point looked at doing summary dispositions, and it decided it was not appropriate for our population. Even though that there are cases where there's, just no merit, no jurisdiction or whatever, the court, could have disposed of quickly. But the judges decided that that was not an appropriate, our population was not appropriate for that kind of decision. I think it is.
Avoiding Latin is also good for the attorneys.
Well, I will say as well, I don't know where it came from, but I know that the board's appeals rights page for old legacy appeals, at some point got added to it information about if you want to appeal, contact Veterans Consortium. And I know for a fact that a fair number of veterans went to the consortium because the board itself in its own decision gave them instructions to do that. But does anyone know when that showed up, how they got there?
No, and I think the court's website has listing of all the current practitioners and by states and things like that, and then you can also reach out to the consortium. So I think there's a couple of places on the court's website that it tries to connect.
I can confirm that does work as an attorney with a surname begins with an A. I've seen multiple veterans just go down the list.
Greg, can you think of it?
Yeah, I would add something I think the court is investing heavily in is public office staffing adequate to speak to people first. So very few places, I think, or not many places in government now can expect to have a live person on the line, but at our court you can't include a binding directory that has my name. So if you're like,
Starts with B.
so we're definitely getting to talk to them.
Do we have any other questions?
This may be a comment. It's a little bit like being at your own wake where folks are singing your praises, but and so not so much a question, but maybe just a validation. Linda, I think you did a fantastic job of really encapsulating as a original member for TVA, but where we've seen growth is we kind of had 2019 was a peak of cases that we took on with between BVA and the court and the work we were doing, and that's been in a little bit of a decline over the past few years, but we anticipate the PACT Act kind of raising that up, and so we see work for the future. But I will say the national helpline, which you referred to, that has only steadily increased, and I've been there for about 4 years, and so I think our version of the public office at TVC, we've really broadened our outreach, our messaging via social media, via conferences, particularly on the other side of COVID, and we've seen really a rise in our interaction of pro se clients coming to us through our helpline, and whether that results in getting an attorney or just advice on how the court works or whatever. We see that as lifting some work off of the court and your public office as well, but we've seen steady growth there.
Chief Judge Barley?
I was just fascinated, Mary, whenever you were talking about the high pro se rate, like in the early 90s. And then you were saying like, well, okay, so the veteran didn't identify the rank that they deserved relief under. So what was your training program like? Because a lot of you were dads and didn't really have a lot of Title 38 knowledge. Like what happened? How did you do that? Sounds like very demanding.
Well, I guess like most jobs, it's just sort of on the job training, right? So we just sort of picked it up, and it was in those early days, the court was creating new law. I mean, we were all kind of in it together, right? I mean, it was a lot of everything was new, And then when they passed the VCAA, everything was new again. You know, the things we thought were settled. Now what is noticed, you know, now with the AMA, it's a brand new thing. So, you know, we're constantly just sort of learning. And I think that's one of the exciting things about this area of law is, you know, you are constantly getting a chance to help shape it. And I think we attract people who are interested, who want to do the right thing, who want to help veterans. We have a lot of people. I'm a veteran myself. We have a number of veterans in the office. But I think it's just really just kind of learning by doing. And particularly in the beginning, the court's case law was really nice. It fit, you know, it was a couple volumes. You really could become an expert. And then, you know, you build on it. So, yeah, I think it was just sort of trial and error.
It was really more about knowing the regulations than the case law, because that's what you had to focus on.
Oh, we just had a comment from Dave Myers, who said that the pro bono program trained 6,000 attorneys with an 83% success rate, and he thanks Judge Hagel for his support. That's all.
Is that everything? All right, well then I would like to say thank you very much to everyone for joining us. Thank you to the panel for walking us through that. And as a final note, if you are interested, in this, as Judge Schoelen stated, there's actually a section of the court's history book that delves into the pro se rate as well. If you were not fortunate enough to attend the judicial conference, you can get a copy of the book on the Historical Society's website. So for the low price of $25, including shipping. Thank you very much.